So, as you already said, that the topic for today is defenses in a criminal trial. But what I understand is most people here might just be law students and very few lawyers or junior lawyers. So, what I wanted to say is, what exactly is a criminal case first? Like, how does it start? A criminal case, as we all know, the basis of which is an FIR or a private complaint filed. Now, in India, because we follow the practice of common law, every case is started by the state of Maharashtra or any state or the union versus the particular accused ABC. Now, the basis of the first case registered is an FIR. Let's just take a case of an FIR. Now, when an FIR is filed, pursuant to that, an investigation begins. And after the investigation, the case comes into an opinion whether there is a case made out or not made out. If the case is made out, they file a charge sheet. And pursuant to the charge sheet is produced then before the court. And then after the court takes cognizance of that charge sheet. And thereafter, charges are framed. And then the trial begins. Now, what happens as a criminal lawyer? What we need to understand is the process of criminal law in our country. What happens is, as in our country, is that no person can be held guilty if the offense against that person is not proved beyond any reasonable doubt. Now, what do you mean by this reasonable doubt? This essentially means that the prosecution, or rather the police, they have this extra burden of proving every case or every offense against every offender beyond any reasonable doubt. That means even if there is a slightest doubt in the entire case, that person deserves to be acquitted and set free. Now, what happens is their criminal lawyers, or rather us, we come into picture. Now, we play such a great role in not just defending our client, but also to make sure that the case put forth by the prosecution, however foolproof it is, we need to find some certain amount of doubt. Now, what do you mean by doubt? Now, if a crime is committed, the prosecution has to prove each and every, firstly, the ingredient of the particular offense which is committed, and then connect those ingredients to the particular facts of the case. And only in such a case, after completion of the trial, after examination of witnesses, after putting forth all the evidences available by the police, if the case is so foolproof, to prove the case of the accused beyond any reasonable doubt. Now, what do you mean by creating a doubt? As a defense attorney, the only job, especially in trial, what we have is to create a reasonable doubt. Now, there are two kinds of defenses which one can take. And in fact, in our profession, there is a lot of scope for artistic liberty, because we can literally create another story of an accused or of an accused person and make it in such a way that this story is also a probability. Hence, the entire story created by the prosecution, however true it may be, however strong it may be, you cannot rule out that this XYZ case is also a probable case which can be. And if the accused can prove that my case, like rather my defense case, is a probable case which can be proved, then I deserve to be acquitted, because the prosecution case is then not proven beyond reasonable doubt, because I have created that doubt in their prosecution case. Now, there are two kinds of defenses which we can say. One is a defense which is provided by our statute itself, the Indian Penal Code. And the second is defenses which may vary from case to case. In fact, all defenses vary from case to case. There can never be a set script as to what defense shall be taken in what case. It's only after, in fact, reading the papers, reading the charge, reading the charge sheet and the statements of the witnesses against you, can you then develop a defense case for yourself. Now, what I would start with is statutory defenses, and then I'll move on to how a lawyer can be creative creative in such defenses, and I'll give you a few examples of the cases I've worked on and I've argued, and what kind of defenses have I taken in the facts and circumstances of that particular case. Now, first and foremost, we start with statutory defenses available in law. The first would be mistake of fact. Now, what do you mean by mistake of fact? In a case where a person is legally bound to do or perform a particular activity, and while doing so, he commits a crime, then he can use the defense of mistake of fact. Now, for example, if a soldier is listening to his superiors and he shoots wherever he is asked to shoot, and he injures a civilian. Now that civilian has some hurt has been caused to him, or he has died. Now in such a case, it is merely a mistake of fact because the soldier never had the intention or the motive to kill that civilian. He was merely following the instructions of his superior, and that was his duty to do so. Now, whether that instruction itself was malified or wrong or right, that is a different point and a different case to be examined and argued. But if we take it in simple terms, if someone is duty bound to do a particular thing and commits a crime while doing so without any intent or without any motive, it is so known as a mistake of fact. Another example would be probably a doctor who is duty bound to perform an operation or a surgery. Now, he may perform a surgery and he may end up killing someone, or the patient might die. Even though the operation may be successful, but the patient might die. But in that case, what needs to be seen is firstly whether the doctor was intentionally negligent in doing so. If the doctor is intentionally negligent, then there can be cases against him under the criminal procedure, under the Indian Penal Code, or under any consumer forum, etc., of negligence. And that is a separate part and separate proceedings. But what I'm trying to tell right now is a mistake of fact when someone is bona fide trying to perform something as a duty and then commits a crime in course of their duty. And hence, that is an exception under Chapter 4 of the Indian Penal Code. Now, another defense which can be taken, another statutory defense rather, is of unsoundness of mind. Now, unsoundness of mind is not defined in the Indian Penal Code or any other code. A person having a mental deficiency at the time of committing a crime, only in that case can a person take a defense of unsoundness of mind. Now, what does that mean? Suppose a person is suffering from anger issues. Okay. And by anger issues, I mean clinically proven anger issues. And in a particular event, when the offense takes place, that person's anger issues takes place. Only in that case can he use this defense. Now, anger issues is an example which I gave is a very light example because we often use the term anger issues in a very complacent manner. But for times where someone has clinically proven anger issues, that is the kind of defense which can be taken. But it is not a simple defense to be taken because under Section 105 of the Indian Evidence Act, it is the onus of the accused to prove his defense, especially when it comes to unsoundness of mind. Now, unsoundness of mind can be of many kinds. I just gave an example of anger issues. It can be of mental retardedness, etc. But when a person does an act, and I mean at the time of doing such an act, he has to be of an unsound mind. And that onus is solely and solely on the accused under 105 of the Evidence Act. Now, this is unsoundness of mind. And for this, it is the onus of the accused to put up his own witnesses, to examine his own witnesses, to put on a particular accused and defense case. Now, thirdly, there would be intoxication. Now, intoxication, as we all know what it means, when a person is intoxicated or rather has been intoxicated by another person. But in this case, it's a little tricky situation. Merely by you being intoxicated, you cannot use this as a defense to come out of a crime. To come up with this defense, what you have to prove is firstly that you have been intoxicated against your will, or that you have been intoxicated for which you did not have knowledge. Now, again, for if you voluntarily get intoxicated and then commit a crime, you cannot use this defense. For example, if you go out drinking and then you are drunk and then you commit a crime, you cannot use the defense of intoxication because you voluntarily got drunk and then committed a crime. But for example, if someone drugs you or if someone makes you drink alcohol and you can prove that fact that someone has done so and pursuant to that you committed a crime, then yes, you can use this as a defense. Now, after this, thirdly, we come to act by consent. Now, what do you mean by act by consent? There are times where two people consent to a particular act, and in the course of such an act, a crime is committed. Now, a very small example would be that of sword fighting. Suppose A and B got into a sword fighting competition or a sword fighting engagement, and during the course of sword fighting, that person has been killed. Now, both these people have consented to this sword fighting, and in spite of the consent, they had to bear the brunt of it, and one person dies. So the other person can take a defense that we both have consented to doing such an act, and hence you cannot hold me guilty of an offense for which the person who was actually deceased or died or hurt has in fact consented for me doing that to him. May it be sword fighting, fencing, shooting, anything, in which case this defense can be used. Now, the most widely used defense, whether it works out or not, is private defense, or rather self-defense. There are a few conditions which one needs to keep in mind before using such a defense. And mind you that whenever an accused uses a defense, that defense always has to be proven by the accused himself. It's not that just because you claim or you assert that this is my defense, it's not that the prosecution has to disprove you. The fact that you asserted that this is your defense, you have to prove that your defense is true. Now we come to private defense. Now, what do you mean by private defense? It's quite self-explanatory. It's self-defense. Now, the ingredients for self-defense. Firstly, it cannot be private defense if the person inflicting any hurt or anything on you is not an offense under the code. If someone does something to you which is not an offense, you cannot then claim that you attacked that person for private defense. Secondly, the right commences as soon as there is apprehension for threat and danger. What that means is, if there is no apprehension for threat or danger, there cannot be a defense of private defense, and this apprehension has to be proven by the accused. Thirdly, as the word suggests, it is defensive and not retributive. What do you mean by retributive? If someone has attacked you, it doesn't mean that you have to attack back. If there is an attack which you can defend, it's only for the purpose of defense. It's like an eye for an eye, as we say. An eye for an eye is not private defense. If someone tries to hit your eye and you try to push him, or that is defense. But if someone tries to attack your eye and you attack the eye again, that is not private defense, and hence you cannot in that case use this as a defense. Thirdly, the right cannot extend to inflicting than it is necessary to inflict for the purpose of private defense. If someone has given you one slap, you cannot murder that person and say that I was defending myself, because you have to see the magnitude of the hurt inflicted upon you or the act inflicted upon you. Just by someone slapping you, you cannot say that he slapped me, so I murdered him. No, that is not what private defense is. Now, one more thing is that private defense is not restricted to your own person or your own body. Private defense goes on to protecting your property as well. If someone is trying to hamper your property, or someone is trying to cause loss to your property, damage to your property, you have all the right to defend your property as well. Now, in what case is there no private defense? When the act does not reasonably cause the apprehension of death or grievous hurt by a public servant on duty, even though it may be just unjustified by law. If a public servant is carrying on a duty and he may not be completely under the cudgels of law, you cannot hold this as private defense to attack that particular person. For example, the bullet pelting or lathi charge, etc. These things may not be completely justifiable under law, but when they are carrying out a public duty, you cannot retaliate back, throw stones, etc., and say that I am performing this as my private defense. And because the police personnel has inflicted lathis and lathi charge on me, I am doing this as a matter of defense. No, that is not what private defense is. Further, with respect to public servant, when the act does not reasonably cause by a direction of a public servant, basically there is a person who's committing the act and there's a person who's directing, like the superiors, etc. So both cannot be under the ambit of private defense. Thirdly, and this is of utmost importance because this is what exactly happens in the court of law, is that what you have to prove when you take a defense of private defense is that you had no other recourse for defense at that point of time. You have to show that you could not approach the authorities, or you did not have the capability to approach the authorities at that particular time, and you had no option but to do what you did. And if the prosecution even points out a slight doubt as to you could have approached this, you could have made a phone call to the police, you could have dialed 100, someone else, you could have shouted out, etc. If any of that sort happens, your defense is gone. There is no defense available to you then. And hence, all these general exceptions which I'm trying to explain right now have a utmost threshold of proving it in trial, because all the onus is on the accused to prove that there was no other way you could approach any other authority or even get to a phone to dial 100 and call the police or any other authority. There are times and there are cases where the private defense is used in a way where you, while defending yourself, cause the death of another person. Now, in what case can this death be caused is also explained under the Indian Penal Code in Chapter 4. What you have to prove if you have caused death of a person is firstly that the assault which you have inflicted, which you have been inflicted on, like if someone has assaulted you, if that assault could result in death, then you are justifiable in killing that other person. Secondly, if the assault which is inflicted upon you may result in your grievous hurt, not just any kind of hurt, grievous hurt which causes impairment of organs or impairment of bone or etc. Only in such a case where it will be justified to take up such a defense of private defense and cause the death of the person inflicting such a hurt, such an act on you. Third, assault with an intention to commit rape. If someone is trying to commit rape on you, then you are justified in killing that other person. Then, assault with the intention to kidnap or abduct. If someone is trying to kidnap or abduct you, then you can use this defense if you happen to kill the kidnapper or the person who's abducting you. It also extends to people who are wrongfully confining you. And if you want to get out of wrongful confinement, you happen to take such a measure where you end up killing that other person, then yes, you can use this as a defense. Another way is another case where you can use it is in acid attacks. If someone is administering acid, may it be acid attack or administering acid to you directly, you can use this as your defense. Now, as I said, that private defense does not just extend to your own person, but it also extends to property. Now, in what cases rather do they extend to property? Firstly is armed robbery. If someone comes and trespasses your home or breaks into your house with arms with an intent to commit robbery, and in such a case, when you can go to such an extent of causing the death of this person who has come to rob your place, then yes, you can use this as a private defense, but that is only in the case of armed robbery. Secondly is house breaking by night. If someone breaks into your house at night, maybe to commit robbery, to commit any other crime, you can use this defense. Then mischief by fire. If someone is trying to set your house or your property on fire, yes, you can use this as a defense if you happen to kill that other person. Then there is theft, house trespass with the intention or rather apprehension of causing death. Merely if someone comes into your house just to cause theft, it is not. But if someone has come into your house for stealing and you have an apprehension that that person would cause your death, then yes, then this can be used. Now, these are a few examples of statutory defenses available in law. Now, what happens in day to day practice is that it's not always that your case fits into these many defenses. Every case is unique, and every time you get a case, you view it with a different lens in order to give the best case for your client. As I have had the good fortune to work on many such cases where I have also taken rather artistic or unique defenses for my clients. It may not always be at a trial stage. You can take defenses for your client right from the stage of bail, etc. So I would like to share a few stories or rather few cases which I've worked on in which I have taken such innovative defenses and rather got orders in my favor before taking those defenses. The first case which I had, not the first case, one of the few interesting cases which I had worked on was a murder case. And in that murder case, there were three circumstances against me. What do you mean by circumstances? If there is no direct eyewitness against you, you prove a case by creating a chain of circumstance which is so solid that will prove in the guilt of an accused. Now, in my case, there were three circumstances. The first circumstance was of last seen. Now, what do you mean by the last seen theory circumstance? What it means is if you are last seen with the deceased person before the person has died, then this circumstance is used against you. The second circumstance which was alleged against me was recovery of a weapon, of a knife, or rather a koita, which was against me. And thirdly was a confession given by my client to his own wife that he has committed the murder. And this is all a part of it. No, this was in fact a very difficult case to get out of because there are very three strong circumstances which were against you. And this was a case for bail. It was not trial, it was bail. But even in bail, you have to come out with some kind of defenses. So, as I said, the first circumstance was of last seen. So, the defense I used was that yes, the circumstance was that he was last seen in this one cafe, and the CCTV of the cafe saw the deceased and my client together. However, the CCTV once taken out and a statement of the waiter and the manager of the hotel was taken, and both said that they do not know my client. So in that case, what happens is that there needs to be a test identification parade which needs to happen so that they recognize the person who they actually saw in the CCTV. However, in my case, there was no such test identification parade. So therefore, this one circumstance could not be used against me, and hence this was nullified. Now, the second circumstance which was against me was a recovery of a koita, of a weapon, so-called murder weapon. Now, on that murder weapon, the murder weapon was recovered by me as in my client. And when it was recovered, it had blood stains on it. Now, that koita was, and my defense to this was twofold. Firstly, the place of recovery of this koita was in an open barren land, in a land which was not of such a place which only the accused had personal knowledge of. It was an open playground and anybody could have gone and planted it. That was my first. Secondly, when the koita was seized, there were blood marks. And when those blood marks were sent for forensics, it just said blood found on the koita. It did not mention that human blood was found on the koita. So I used the defense that this is not human blood. It cannot be conclusively said that this is human blood. It can be any animal blood. and hence this second circumstance was also nullified against me. Now there was a third circumstance of a extrajudicial confession. What do you mean by extrajudicial confession? Is that when a person confesses to another person about his commission of the crime, it is an extrajudicial confession. In my case, such a confession was done by my client to his own wife, and he had explained in her statement, she herself gave a statement that he came on so and so night and he told me that he has committed that particular crime. Now, what was used by me is section 122 of the Indian Evidence Act, which is the section which has the capability of proving privilege between spouses, privilege communication. Now, what about privilege communication is that what is shared in privilege between the husband and wife cannot, the person cannot be compelled to depose the same in court. So this particular incident can never be proven against me, because whatever statement is against me can never be proven against me. Hence, the circumstance was also gone, and hence my client was therefore released on bail, because none of the three circumstances prima facie could be even proved at that point of stage. Of course, at trial things may be different. Trial has not started yet, so when it comes to that, these same defenses will be used by me in trial, and thereafter, whatever the conclusion of the trial is, we may accordingly see. Now, one of the most common defenses, which other now this case is over. Now, another common defense is just denial of your existence or denial of the identity, as we call it. In every case, in a criminal case, what criminal lawyers often do, or rather always do, is just deny. Even if you know that something is, they are saying that with some authority, you just deny it, because the entire onus of proving it is on the prosecution. If you accept it, that means it need not be proven against you. But if you deny it, the prosecution has all the onus to prove all the circumstances against you, whatever you have denied. Even if there is a CCTV footage in which you've seen, we still deny it, because it is the case of the prosecution, and the prosecution needs to prove that it was me who was in the CCTV footage, and I need not accept the same as it is. That is the basic rule which all criminal lawyers follow. Of course, subject to certain exceptions where you have to accept in certain cases, but that depends from case to case. But I would say that that is quite a rarity. In most cases, it's blank and complete denial. Other thing, another example which I would like to give is a cheating case which I had worked on. In that case, what had happened is that my client had taken money from another person and had promised to give him flats. Pursuant to that, there were agreements and leave and license agreements made, which were signed between the clients, between the two people. Now, what happened is that my client had taken the money and not returned the money or given him the property which he had promised according to that MOU agreement, leave and license agreement, etc. Now, for any person, this would seem like a straightforward case. However, after putting much thought, me and my senior also came up with this defense that because my client and the person against me, I mean, for the complainant, sorry, not against me, the complainant, both are Muslims. We came up with a defense that in Islam, interest is haram. And this entire transaction was a loan transaction. And because we could not show it as interest, because it is haram in our religion, we showed it as a property transaction. And that both of us voluntarily got into such a paperwork and transaction only to bypass our religious laws. And this case rather is still pending in courts, but this is the defense which we have taken up. So we are eagerly waiting to see what actually happens with this defense. It's quite an ambitious defense which we have taken. Another defense which is often taken in criminal trials is it's not just a defense, it's rather a mode in which we discredit the witnesses. What do you mean by discrediting witnesses? When a witness deposes or gives examination, The basic aim of any criminal lawyer is to make sure that this person's testimony is not credible. Now, what we have to do for that purpose is that examine that witness in such a way that we have to prove that there is no doubt that this person is lying. I would, in fact, want to give an example of a case which I worked on in which we had taken up such a stance of discrediting a witness. It's, in fact, a stance which is taken in most of the cases. So, I'll just give a brief of a case which I worked on. It was a murder case. And what had happened is my client was a woman who is alleged to have murdered her ex-boyfriend's fiance. Now, what had happened is that she happened to be in her ex-boyfriend's house. The fiance came to know this. She flew to the ex-boyfriend's house, and then they had a big fight that night. But ultimately, the fiance and the ex-boyfriend, they went and slept in the bedroom, and this person, this woman, was outside. And what gotten into her, we don't know. But she went to the petrol. This is the case of the prosecution. It's not what I'm narrating. This is the case what is alleged against her. Is what happened is it's alleged that she went to the petrol pump, took petrol, and burned the girl alive in the morning after going to her room. The person suffered about 80 to 85 to 90% burns. The girl when she was taken to the hospital, and ultimately she passed away. But what is interesting to note in this case is that this ex-boyfriend guy and this girl was sleeping on the same bed, and in the picture it happened that the entire bed was burnt, but only slight burns were caused to the guy only on his right palm or left palm. And that itself was so conspicuous, right? Because if someone right next to you is completely burnt, how could you only have just slight burns? So our case was to discredit the witness who is the ex-boyfriend. Now, our basic case was that he was trying to tutor her from the very beginning, from the time she was taken from the place of incident or other place of crime to the hospital. And during that period, we had witnesses to show that he kept tutoring her that she was killed by the girl. She was killed by the girl. And because of that state, that because she was half conscious, subconscious, and she could not have thought anything by herself. She was only relying on what this person was telling her. And if a person keeps telling you that XYZ has killed you, XYZ has killed you at a particular time when you're so vulnerable, you have no choice but to believe that. And she, when she was admitted in the hospital, she was alive for about 24 hours. And in that 24 hours, she gave a dying declaration. Now, in this case, our entire agenda was to disprove the testimony of the ex-boyfriend and say that he is a liar and he is lying, that all this circumstance which he said that she came to a room, she walked into the room and then killed her, is a complete farce and a complete lie. And hence this was, the trial is still going on, we are still seeing what's happening, and this was the case where the only object was to prove that he is a liar because he was the sole eyewitness to this entire case. Of course, there are other circumstances of the door lock, of watchmen seeing, etc., but those were all minor circumstances against us. The main circumstance was this eyewitness, and when there is a case of a direct evidence or other eyewitness, the main defense which one takes is of discrediting the defense. Now, as you see that this is such a vast topic that each case is unique and each case has its own nuances. So you can never know what defense to take when. And in our profession, we are so fortunate to also use our artistic minds to see what exactly are the defenses which could be taken. And it's all upon us lawyers to show our creativity that what defenses can be taken. Of course, there are statutory defenses, but they are minimal statutory defenses. What happens in reality is that when you read a particular brief and you see the case against you, And there are so many times where there are so many loopholes. And as a defense counsel, as a defense lawyer, all you have to do is try to overcome those loopholes and rather take advantage of those loopholes and create a story within the four corners of your case and make sure that there is a reasonable doubt created. And once a person succeeds in proving that reasonable doubt by leading perfect evidence, by doing perfect cross examination, the person can be not guilty. Now, what I mean by perfect cross examination is nobody can have a perfect cross examination. It is an art and it is not a craft. One has to have the art of doing so merely by, of course, practice, of course, makes it better and better. But it is an inherent art which one needs to have. And of course, I'm not saying that there is a particular ABC or a book which is written saying that you have to follow so and so, so and so, so and so. In every case, when a person is examining any person, you cannot plan out a defense or you cannot plan out particular questions and go and ask those questions, because what happens oftentimes is that you plan out questions and then you just go and the witness answers something completely different. So on that, in that spot itself, you have to come up with another, and that's why what is essential for a great trial lawyer is presence of mind, because you do not know when things might turn against you. Because the witness, you might think that he or she will answer in ABC, but there is complete XYZ, and then you're just taken aback. And at that moment, you might have to improve your defense, or rather, make sure that the witness comes back to ABC by showing exhibits, etc., etc. And that's what, of course, experience is required to know the entire law of evidence, which cannot be covered, of course, in a span of 45 minutes, half an hour, 1 hour, whatever. But what is essential is that one needs to be extremely creative and also, I would say, ambitious when dealing with a criminal trial, because you have so much material to come up with a defense theory, and it may fail, but it is worth trying, because now you have two weapons with you: one, your defense theory which you have to prove, and on top of that, the theory of the prosecution which they have to prove against you beyond reasonable doubt. When you prove your defense theory, it does not have to be proven beyond reasonable doubt. It has to be proven with the preponderance of probability. You have to show that there's a probable cause of this defense happening, but the prosecution will have to show that this is beyond reasonable doubt happening against you. So you are at a much better footing as a defense lawyer and a defense counsel, and hence when it comes to trial, you have so much bandwidth to play around and do so many artistic things here and there. And I would say that in our country, I would be very frank and honest that trials do not conclude or complete in like 1 month or 2 months. It takes years and years. So when you start off with a defense, you yourself become better at the subject, because as like we still practice law, so we know it is a practice. So with practice, we try and become like perfect. And every time you go for that trial, you come up with some new things and new defenses. So that's the entire work of a lawyer, that how in one single case you can just keep getting better and better. I'm not justifying the fact that in our country the trials take so long. I mean, it's really thing that it takes so much time. But I mean, this is what the state is because of the pendency of cases, so many number of cases, lack of judges, etc. That's why we are where we are today. But of course, we cannot change the system in a day. But till then, we'll have to live with the system. So this is what the work of a criminal lawyer in trial is, and I hope I could give like a brief on what all defenses which could be taken, and I try to share my personal experiences on what defenses I have taken. I hope I could put some value to this topic which I was invited for.
Yeah, I have a question, sir, with regard to
Yeah.
the intoxication as a defense. So,
Hmm.
in case a person who is addicted to a particular drug or a alcohol or something, if he is
Mm-hmm.
taking that drug, but he is taking it voluntarily or he has taken it voluntarily, but he is addicted.
Mm-hmm.
So, will it be used as a defense?
So
Can it be
in
used as a defense?
that's a no no I understand, that's a very good question. What happens in such case of an addiction if the addiction is a proven addiction, then you cannot use the defense of intoxication because you're voluntarily doing it. So, but you can widen the scope of unsoundness of mind, and that your addiction has caused and made you to go to such an extent that it has caused you to become of an unsound mind. But again, as I said, that the onus is completely on you to prove to what level your addiction is and whether your addiction is a medical condition which has made you commit such a crime. So that would be my answer, my view on it.
Sir, what are the qualities required to become a criminal lawyer?
You don't need any specific qualities. I mean, how do I answer this? You don't need any specific qualities rather to become a criminal lawyer. It's mainly your interest, and of course, like how, like any other, you just need to work hard. You need to be I feel that you need to be extremely interested in that subject. If you're not interested in that subject, you cannot be a good criminal lawyer, or rather, in any profession, you need to be interested in that subject. What I frankly believe and practice is constant reading and constant, constantly being in touch with the law, because the law keeps changing and you have to keep reading the subject, because every time something new comes up, you need to know and you need to think by your feet. You need to have your entire procedural law, that is the criminal procedure code, at the back of your hand, because you need to know what to do when, and you need to do all the offenses. And there is no specific quality which is required to become a criminal lawyer. I feel like with hard work, I guess hard work is the only quality, but that's like just a general quality required for anything. There is no specific quality, I would say, to become a criminal lawyer. So I don't know that I answered your question rightly, because when I am in search for the same, and as we say that we are still practicing lawyers, all of us, we learn every day. So yeah, we are all looking for that special quality which will make us best.
So my question was actually in pursuant to what you said, that how does one feel as a criminal lawyer, knowing you might be saving a murderer who's, who's, I mean, you're representing them, but ultimately you can see the other person really in a sad state because they have lost a loved one. And also, how do you feel about safety, that you're representing somebody who may be violent in nature?
No. So, as I already said, I think I answered this partially in the previous question, that what we are trying to do is we are not trying to encourage a criminal. We are not trying to say that you should commit crimes and we are here for you. We are trying to say that you have committed a particular crime, and whether or not you have committed a particular crime is a matter of trial, a matter of issue, matter of investigation. You have come to us with a case, with a brief, and we have accepted completely professionally. So we have to do justice to our brief, and we are not trying to defend someone beyond our personal capacity or beyond the law. We are constrained within the law and trying to get a look of the best defense possible for our client. And it's not like we decide the fate of the client. We put forth the case in front of a judge, and then the judge decides whether this should be considered or not. So we have to basically do our duty of representing the client to the judge, and then the judge, in its right mind, will then decide whether this person is guilty or not guilty, and we accept the same as it is. So when we pick up a case, we do not pick up a case and firstly ask the question to the client, ki, have you done this? No, we never ask. We're like, okay, this is the case, you give me the papers, we'll go through it, because we would like our mind to not be prejudiced, so that we can work better. Because if someone comes and tells you, ki, हाँ मैंने किया है, now do what you want, so then it's just impossible to work with such people, because then you're just prejudiced. Then you will never put in your mind and effort in such a place where you're like, okay, I need to help this person out. Now, the second part of the question is, what impact would we bring to the society in such a case? But for that matter, as I said, we represent the client and the judge will decide whether that person should be let out or not. But what we also do is try and get justice to the victims as well, because of course, predominantly we are defense lawyers, and 70 to 75% of our cases are cases for the accused and for defense. But also there are so many people who are accused, who are wrongfully accused, so, and wrongfully sent behind bar. So even there could be a question which I may ask you, that isn't that unfair, and isn't that a good thing which we try to help these people out to come out because they've been wrongfully inside. That is also there. And also we represent a lot of victims as well in crimes where in so many crimes we also represent the victims. So it's not that always we are on the side of the wrong. It's that we are extremely professional and we are doing complete justice to the brief which we get in our hand. That's about it.
My question is, where do you find a procedure for bails in criminal law? Say, for example, if the crime is done in UP, in the state of UP, and there is one accused, innocent person who is in Bombay, who has been taken over there, and then he goes and applies for an anticipatory bail in the High Court of Bombay. Now, where all these procedures are mentioned in criminal law?
There are two kinds of bails. One is pre-arrest bail, which, as you rightly said, anticipatory bail, and then there is regular bail, which is after arrest. Now, depending on whether the case is magistrate tribal or sessions tribal, you move that particular bail application in that court. If the case is magistrate tribal, you move the magistrate court under section 437 of the Criminal Procedure Code. If it gets rejected, then you go to the sessions court. If that gets rejected, you go to the High Court and then Supreme Court thereafter. Same with sessions tribal cases, you move it before the sessions court under section 439 of the Criminal Procedure Code. Pursuantly, you can approach the High Court and then thereafter the Supreme Court. Now, what question which you raised was of cross-jurisdiction bails. Now, this is a very interesting concept which is now being decided by the full bench of the Bombay High Court, and I am in fact a part of that as well in the reference case, where the judge is deciding whether can the courts in Bombay protect a person outside the jurisdiction of Bombay. It is colloquially in our terms called as transit anticipatory bail. If a case is registered in UP against a person who is in Bombay, and this person is saying that the UP police will come here and take me and go, what this person has till now, and there is a judgment called as B.K. Nair in the year 1980, of Bombay High Court, which laid down that the courts can extend its jurisdiction in a case which concerns liberty of a particular person. And this liberty can only be extended for a temporary period of time, for a period of 3 weeks, 4 weeks, whatever the judge feels right. For this person to go from Bombay to UP, to approach the courts in UP to apply. Now, if the case is registered in UP, the person cannot apply for regular anticipatory bail in Bombay for a case which is registered there on facts. The only thing which a person can actually apply for here is transit anticipatory bail to protect him from arrests from going from Bombay to UP in that particular period. And after he goes to UP, he'll have to again apply for an anticipatory bail on the facts and circumstances of that case which is alleged against him in UP.
So what are your views on the new Criminal Identification Bill 2022, which gives the power to police to collect biometric scans and any physical measurements with respect to them being under arrest or under trial or convicted? Is basically creating a record. So since you brought up the topic of misuse of the powers given to the police enforcement and the law enforcement, now say an accused is actually innocent. He's just an accused at the end of the day. How is that actually helpful with respect to you're actually creating a record, you're misusing it in some way? So what are your views on that?
Actually, I would be very frank with you that I have not read up too much on this subject. But what I could possibly tell you is that this particular act which is come up before us right now is not something unique. It has been practiced in most countries. In fact, in most developed countries, to keep a record of people who are accused. And this essentially happens is because right now what the situation is, if a person is committing a crime in Mumbai and if the person goes and commits a crime in Jammu and Kashmir, there is no central book of record which can show that this person is already accused in this particular case in Bombay. Hence, according to I feel that it is very important to note this, that there needs to be a record and biometrics. So, because if a person has committed a crime in Mumbai with your name is Rishabh Singh. So, if a person has committed a crime called as Rishabh Singh in Mumbai, but if he goes to say Jammu and Kashmir, changes his name to maybe Akshay Pai or something, then he can just go and commit that crime in Jammu and Kashmir, and there's a complete change in names. So that time the biometrics come in picture, and hence I think biometrics fingerprints are also essential to be kept on record, because then to identify the person in that case.
Please throw some light on fake encounters cases by police.
Okay, so fake encounter cases are in fact rather tricky because, as I said, that the defense of mistake of fact that when a person does a duty which he is bound to do by law, whether it can actually amount to a crime and whether it can actually be used as a defense. Now, what is happening, as the word suggests, fake encounter. Encounter is something which needs to be used in the rarest of rare case when the person is fleeing from custody, etc. In those particular cases, and there are like certain categories in which encounter can actually be executed. But what is happening now is that there have been cases where these things have been, created with a view to commit this particular crime. Maybe it be political gang, whatever, etc. So now, as we are seeing that there are so many cases of fake encounters which are going on, and of course, there is a big threshold which needs to be proven is the intention, or rather the situation in which such a crime was committed. So when you say that the particular encounter is fake, you have to know that why it is fake. You need to know as to whether there was any malefice by the police personnel to commit such a crime and kill the person who was rather in custody at that point of time, and that encounter was in fact not justified and was fake for whatever XYZ reasons, may be political, etc., as I already said. So it is a subject which is extremely wide and it may depend from case to case and it may vary a lot.
Sometimes defense opt for partial liability against total denial. What is the best option?
Now, see, now this is a question which the best option would obviously be after seeing the papers. Now, if your paper suggests that there is something which you cannot particularly deny and it is so strong against you that you have to go for admitting it partially, but it has to be done in an extremely smart way. You cannot partially admit something when you know that it might cause damage to you or rather your case. So I would say that, I would always go for the option of total denial in most cases. But of course, there are cases where that may not work and you might have to resort to this. But of course, it's a case to case basis and there cannot be any general advice or rather general viewpoint with this respect.
I request you to give us some important tips to law students out of your experience.
I would say what I like to practice. I would suggest that every person every law student firstly needs to at least start going to court if they're interested in litigation, which I'm trying to say. If you're interested in whatever corporate field, etc., you probably go and intern. And interning is the best time because you have zero liabilities. You have to not, you do not, you're not answerable to any person. You're not answerable to your seniors, to your clients, but it's the greatest opportunity to learn. Along with internship, moot courts. I would suggest that every student who's interested in litigation and practicing in courts has to participate in moot courts and go for as many moot courts as you can in your junior years. Thirdly, I would suggest that every student should start reading a lot, reading the law a lot, reading about great lawyers a lot because that inspires a lot of motivation in you. And also, after reading it, after you grasp the entire topic, start writing about it. And the more you try and write articles, write research papers, the more you become confident in that subject. And more often than not, in our case, what you need is research skills. Like you need to have great research skills. So if you start developing it from the very beginning since you're a student, and ultimately when you actually turn out to become a lawyer and you have to argue in court, you are much more confident in your persona and that reflects upon your case and your advocacy. So I would say that internship, moot courts, and research. That's the three things, apart from academics, of course.